The High Court on Thursday dismissed an application by former Deputy President Rigathi Gachagua to suspend the hearing on his impeachment pending the determination of his appeal.
Issue number 3.
During the mention for the directions on how the case should proceed in the court, Gachagua's lawyer Ndegwa Njiru argued that the matter before the Court of Appeal could lead to the dissolution of the bench and that it was important to wait for the determination.
All what we are asking is the court be reasonable enough to create time for the Court of Appeal to adjudicate over the matter that is pending before it. It's a fundamental constitutional question that is being raised that will inform the manner in which future benches of judges will be empaneled and who will empanel them. So that case will impact the posterity of how the bench will be constituted.
This was further reiterated by his counsel, Dudley Ochiel, citing the level of public interest that the case had attracted.
So the Court of Appeal has warned us against making absurd orders. It would be an absurdity for you to order that Mr. Kinyanjui and Mr. Mwilu, who are both listed the Deputy President as a party in their petition, can proceed. Would it mean then that when we come back from the Court of Appeal, you now then convene a new hearing so that the Deputy President can be heard after the fact? It would be a waste of judicial time for you to order otherwise than that this matter should be stayed.
The application was vehemently opposed by respondents including Senior Counsel Tom Ojenda representing the Senate, who asked for the case to be expedited so as to save on judicial resources and time.
Because he stood up, the Nyamau and Waititu cases support our position that parties be heard or matters be heard expeditiously after compliance. And Lord, we requested for 7 days. The court can extend that timeline so that at least parties have complied. But Lord, in response to my friend Mr. Kinyanjui, he's ready to proceed the way we are. And my Lord, if you give timelines for compliance, I remember, my Lord, the empanelment in Kinyanjui's matter was done by the Chief Justice.
In their ruling, Judges Ogol, Mugambi and Murima said Gachagua's prayer was a camouflaged application for stay, which they had already dismissed in October last year. The respondents were given 14 days to file replying affidavits before the case is next mentioned for fixing of a hearing date. Alan Wino for K24.